Hi, I am Dr. Elo, one of the elite ICE 50 avatars to present this interesting article on California Statute of Limitations. One of two California caps, non-economic damages in medical malpractice cases. Learn about that and other important state laws. Updated by David Goguen, JD. As a patient in California, if you've been harmed by the negligence of a doctor or other healthcare provider, you might have a viable medical malpractice claim. So, it makes sense to get familiar with the different state laws that could affect any lawsuit you're thinking about filing, including time limits for getting a medical malpractice case started in California courts, special procedural steps that plaintiffs must take, and California's cap on certain kinds of medical malpractice damages. All states have very specific deadlines for filing medical malpractice lawsuits, set by laws called statutes of limitations. In California, a medical malpractice lawsuit must be filed no later than 3 years after the date of injury, or 1 year after the plaintiff discovers, or through the use of reasonable diligence should have discovered, the injury, whichever occurs first. In plain English, that means once you learn that you've been injured by a healthcare provider's mistake in California, or once the circumstances align so that you should have learned that you've been injured, in the eyes of the law, a 1-year clock starts ticking on your right to file a lawsuit in court. But if more than 3 years have passed since the alleged malpractice occurred, you've lost your right to file a lawsuit against the healthcare provider. Learn more about when it's medical malpractice and when it isn't. This rule, and the special deadlines and exceptions discussed below, can be found at California Code of Civil Procedure Section 340.5. Medical Malpractice Statute of Limitations for Minor Children in California. In California, medical malpractice lawsuits by, or on behalf of, a minor child must be commenced within 3 years from the date of the alleged malpractice, except that lawsuits by, or on behalf of, a child under the age of 6 must be filed within 3 years of the occurrence of the malpractice, or prior to the child's 8th birthday, whichever timeline provides a larger filing window. California provides an exception for minor children in cases of fraud. The law states that the statute of limitations will be tolled, meaning the clock stops running temporarily, for any period during which the minor's parent or guardian, the defendant's insurer, or the healthcare provider committed fraud or collusion in connection with the failure to bring a medical malpractice action on the minor's behalf. Exceptions that could extend the medical malpractice filing deadline in California. There are a few situations that will toll, the statute of limitations clock in California medical malpractice cases, including notice to healthcare provider required in California. The law also provides that if the notice is served within 90 days of the expiration of the statute of limitations, the time limit for starting the lawsuit will be extended 90 days from the service of the notice. This rule can be found at California Code of Civil Procedure Section 364. For Part 2, go to California Statute of Limitations. 2 of 2 Legal Notice. This article is for informational purposes only and does not constitute professional advice. The views expressed in this article do not necessarily reflect those of ICE 50. One must consult with their legal representative for any and all legal advice.